All right, up on the top left of your screen, you will see the live on YouTube. And we are now live streaming this hearing, and I will call it officially. This is Lefkoff, Rubin, Gleason, and Russo versus Walter H. Schwab, Internal Revenue Service, the Wycliffe Condominium Association. All right, up on the top left of your screen. Okay, give me a second to stop that. And we are now live streaming this hearing, and I will call it officially. This is Lefkoff, Rubin, Gleason, and Russo versus. Okay. Let's make sure that my my work there is done. Give it 1 second. Okay. This is Lefkoff, Rubin, Gleason, and Russo versus Walter H. Schwab, the Internal Revenue Service, the Wycliffe Condominium Association, and Fannie Mae. And this is 2020 cv340741. I thought we would begin with some introductions. Mr. Gleason, you want to go first?
Yes, Your Honor. I'm Andrew Gleason here, representing Lefkoff, Rubin, Gleason, and Russo. We were the foreclosing attorneys representing SunTrust Bank, now known as Truist Bank, that did the underlying foreclosure sale.
Okay, Mr. Henderson.
Hey, good morning, Your Honor. I represent Mr. Schwab in this case. I believe this is maybe the second time we've been in front of Your Honor with this one.
Okay.
It was a different proceeding before.
Okay. And is this, Mr. Henderson, are you taking the place of or appearing today for Allison Rodans?
That name doesn't ring a bell.
Okay.
Sean, do you recognize that name?
Yes, Your Honor. Ms. Rodans was had a client that has since been dismissed out as of December of 2020, but I can't remember the name of the lender. I believe the lender was Mr. Cooper.
Okay, great. Thank you. That makes more sense. So you're representing Mr. Schwab. Mr. Renerick, excuse me, Renerick, you want to go next?
Thank you, Your Honor. I represent the Wycliffe Condominium Association, Inc.
Okay. And Mr. Powell.
Good morning, Your Honor. I represent the United States, aka the IRS, or doing business as. And just a point of clarification, actually, the United States should be the proper defendant, not the Internal Revenue Service, but
Pardon
we're
me.
still proceeding. Yes.
Okay, great. All right. Obviously, I think I think our hearing today probably centers primarily on the claimants. But would you like to go first in the nature of an opening statement, Mr. Gleason?
Yes, Your Honor. I can give the court kind of a brief summary of why we're here. Essentially, we are here to interplead funds that were left over from a foreclosure sale that occurred. The property that is the subject of the foreclosure sale was 37 28th Street, Atlanta, Georgia. This was property that was owned by Mr. Henry Schwab, who took title by quitclaim deed back in September of 1998. He obtained a mortgage, granted a security deed to SunTrust Bank in security for a loan for $100,000 in July of 2005. And then in May of 2018, it appears that there was a sheriff's sale that was conducted with the Wycliffe Condominium Association taking title. That deed, I believe, was recorded on June 5th of 2018. SunTrust Bank was not listed as a defendant in that lawsuit, thus preserving SunTrust's right to foreclose. Mr. Schwab then defaulted on the SunTrust loan, and SunTrust conducted a non-judicial foreclosure sale dated for September 3rd, 2019. The property sold at the foreclosure sale to Architecture, Engineering, and Construction, LLC for $117,000. And I understand that this may be a company that Mr. Schwab actually owns or has some sort of ownership interest in it. After payoff of the SunTrust mortgage, or I should say the SunTrust loan, all the fees and costs, we have $15,253.47 that's left over in excess proceeds. We were uncertain as to who to send those excess proceeds to, given the previous litigation involving the Homeowners Association, Mr. Schwab, as well as the fact that there appeared to be liens to the IRS for probably back taxes. So we filed an interpleader action back in September of 2020, which we then amended in December of 2020 to add defendant Nation Star Mortgage, DBA Mr. Cooper. They have since been removed along with Fannie Mae. Both those parties have been dismissed out. We are showing total costs of this action, which is going to include filing fees and service charges of $414.43. So when you take out the costs of the lawsuit, we're looking at left over for the court to disperse. It looks like $14,839.27, and so that I believe is the amount that the court could distribute. And then, of course, if the court feels it's appropriate to grant any attorney's fees to my firm for the work that we've done, that could be taken from that, but that is up to the court. That's the basic layout of what we're looking at, Your Honor, and I think the parties have all filed briefs and made claims to those funds. And so I really think at this point, it's probably up to the court to hear the testimony and argument from the counsel for the parties that have made claims to determine how the funds are to be distributed.
All right. Thank you so much. So let's see. Let me just look at one thing. Unless y'all have previously spoken about an order in which to go, I'm looking for the amended. Who wants to go first?
I will.
Mr. Wendrick raised his hands first. Go ahead.
Whenever the court's ready.
You go ahead.
Okay, very good. Your Honor, the condominium in question is 2 units, like Mr. Gleason said. The upper unit's owned by Ms. Jennifer Kerr. She's not a party, technically. The other member was owned by the other unit was owned by Mr. Schwab. This case today is sort of an epilogue to other litigation we had in the same division of the court. And I will touch on that without belaboring it. Back in 2014, we got a foreclosure judgment, and we actually did a judicial sale in May of 2018 and purchased the unit. And the unit remained the association's through the time of Mr. Schwab's default on his second mortgage.
Can I ask a question?
Sure, please.
And it's really more for my edification. It's interesting. Did Wycliffe take it? Was that foreclosure subject to the first mortgage on the property?
Yes, first and second and IRS. We did not foreclose them out.
Okay, so first mortgage was SunTrust, or was that?
SunTrust mortgage was first, which is unusual for them because usually they're second. SunTrust Bank was second, and then IRS was after them.
Thank you.
So that simplifies my explanation. So one of the owners was foreclosed out by his junior lender, which was SunTrust Bank. It changed names of servicing, but this would have happened in September of 2019. Now, Mr. Schwab used a company, Mr. Gleason alluded to this, but I introduced a deposition where he'd admitted that the company that he used to buy the unit, he owned 100% of the company, and the company had hundreds of thousands of dollars at its disposal to pay the mortgage off or purchase the unit at foreclosure, which it did in September 2019. So Mr. Schwab controlled the purchase, and I don't think there's any dispute about that. None of the other parties have questioned that. He controlled all of its money, and he controlled the company 100%. As I mentioned, as the Homeowners Association, which took over his unit, we traded our judgment and some enforcement expenses that accrued up to that date for about $64,000. So we had $64,000 in the unit when we lost it, but we were a homeowner. We're not claiming under any lien theory. No, ordinarily, and I think the court's familiar with this, so I don't want to belabor it. Ordinarily, when you have a foreclosure that's non-judicial, all the junior liens are wiped out underneath the, there's exceptions, but the junior liens are wiped out, and then the homeowner is wiped out. And in this case, Mr. Schwab's company overpaid the junior foreclosing lender by about $15,000. And the foreclosure firm, as you know, initiated this action. So there's only $15,000 or so at stake. And the rule is, nobody has cited anything that says anything different. We briefed the court. When there's excess proceeds collected, the money first goes to the wiped out lien holders, very important, wiped out or divested, and then it goes to the homeowner. The IRS is the only lien holder ahead of us in this case. And I'm trying to think of the best analogy. Sort of, if you get excess proceeds, it's got to be a consolation prize. So if you get voted off the island, then you leave and you may get something, and what you get is in the order of where you were in the totem pole. A higher priority person is divested, takes before the homeowner. However, I'll show in a minute that the IRS was not divested, and they still have their lien. But you only get your ticket if you're divested, where you can get the money, the excess proceeds. I just said a minute ago the IRS wasn't divested, and I could explain how I know this. I cited law in a supplemental brief several days ago, which shows that if the borrower being foreclosed reacquires a property at foreclosure sale, the liens that were on there on his or her account, on that buyer and former owner's account, stay on the property, or they reattach. And the reason is a borrower that defaults on two loans can't pit two creditors against each other to get their liens to cancel out, and they swoop in and take the property free of liens. Mr. Schwab was trying to do exactly that. He had enough money to buy the property at foreclosure sale and wipe us out as the homeowner, which he had a right to do, but he also wiped out the IRS lien, or tried to. And he tried to do that by taking the property in the name of a company, which if he'd just acquired in his own name, which the unit had always been in, there'd be no need to explain this. The IRS doesn't lose, they retain their liens at whatever interest rate. We, the homeowner, the association, were the only ones wiped out. But again, we're only proceeding on the homeowner theory, not on the theory that we had of the liens. As to Mr. Schwab's position, he's in default. He didn't reopen the default, and he mentions in some of his filings a filing of a Chapter 11. But he had 4 secured creditors he was supposed to pay, and when I deposed him about this, he eventually did. At one time or another, he defaulted as to all of them. There were 2 mortgages, the IRS and Wycliffe. He didn't pay any of them, and as this plan said, he had to. So he's the reason we're all here, and it's just gamesmanship, Your Honor. He didn't file a brief, and any arguments he wants to make today, I think he abandoned because he didn't preserve them. The IRS, I have found Mr. Powell in my very brief time knowing him very pleasant, but I just got a 75-page filing on my way back from my other court. I went through what he said, and it's deceptively simple. They answer and they say they're entitled to excess proceeds through the liens, but never. I don't show, nor do they ever say that their lien was divested. And without a divested lien, they don't get to participate in the excess. Again, the IRS retains its lien because the only party divested is Wycliffe, and the court should find that we have priority over the IRS. A couple things I think that Mr. Powell was mistaken about. We're not trying to say we have priority over IRS as the homeowner. We're the homeowner. They had a superior lien to us. The difference is they stay on the title, and they're on the title to this day because Mr. Schwab just purchased the property through his company. They didn't lose anything. It's just you put the deed in one name instead of another is all it is. And the second, we're not claiming under a condominium lien. We're only claiming under a homeowners association theory. The IRS doesn't cite any legal authority to say we're entitled to the money because we weren't divested or so-and-so. They do have priority over us, but they can't show they weren't divested. In other words, I'm sorry, they can't show they were divested. So because they weren't divested, they don't participate in the excess. I don't know if the court has any questions.
Plenty. Okay, so, and most of it is really just, because I've gone through the brief, and most of it is just my interest. And I'm very familiar with the situation, and we've had it in a couple of other suits, I think, or at least one other. Okay, so Wycliffe forecloses on its liens in 2018, and were those association liens?
It's a combination of 2 things. One is we had a judgment for $24,000 and change.
Okay.
Okay. There was a balance of about $50,000 in enforcement expenses. It took 3 years to accrue. I think we had to defend 3 appeals. There were bankruptcy rights we had to vindicate because we were trying to protect our rights as a secured creditor. And we defended several lawsuits from Mr. Schwab. So Judge Baxter, I have a copy of the order here. Judge Baxter let us bid in. I'll look at the order. Sorry. Case number 2014cv340741. Related case. He let us bid in enforcement expenses. So whatever enforcement expenses we had, we credit bid for that condo. We can't pursue those anymore.
Okay. And that was the 64?
Yes, ma'am.
Okay. Okay. All right. So Wycliffe bids in 64, gets, let me say simplistically, title to the property subject to the first and second mortgage in IRS.
Correct.
Okay. Then the first mortgage company decides they want to foreclose, so they don't have to cover. Second mortgage company decides they want to foreclose, but they don't have to cut. All right. So they could have taken a credit bid. Or maybe they did take a credit bid.
The second mortgage, Your Honor, was
Yeah, the 2019 foreclosure.
that was a non-judicial. So
Was that?
it was a non-judicial foreclosure.
Oh, non-judicial. I thought you said unconditional.
Non-judicial.
Okay, so did they make a credit bid at the foreclosure sale?
No, Mr. Schwab, as I recall, Mr. Schwab, I wasn't there, but Mr. Schwab purchased the property through his company and with the rest of the public there.
Right, but SunTrust at that point was only looking to recoup its losses.
That's right.
Okay, and if this happened in 2019, there may have been other bidders there, but Mr. Schwab or his company walked away with title, and you legitimately at that point were cut off.
Yes, that's right.
Huh. Okay. Okay, so you want this $14,000.
Yes.
And why do you get it?
Well, because why do we get it? Because we spent $64 for the unit. We got a unit which we owned for 15 months, but the homeowner is the one that gets paid if there's no liens that are above them that have been divested. In this case, there are no liens that have been divested. The first lender still has their mortgage. The second lender is gone. The IRS still has their lien, so they're still on the title, and they still have a lien on the property. We're cut off. We don't have anything anymore to show for what we lost. So I only mentioned that we got $64,000 to show that we paid something to be where we were. And that
sorry, Mr. Weintraub, could you slow down just a little bit, please?
Oh, sure. I'll repeat. So I'm only just trying to say we paid 64 to be where we were in the unit, and then we lost the unit in the foreclosure of the senior. So when the excess proceeds came in, there was no divested lien holder to pay them to. We're the only one standing because the IRS still has its lien because they weren't wiped. When Mr. Schwab came and bought through his company, he didn't get rid of the IRS lien. The IRS lien reattaches.
You did what with the IRS?
The IRS lien reattaches.
Reattaches. Okay. And the theory is not statutory, correct?
Correct.
Is it equitable?
It's partly equity, and it's partly just based on the concept that Mr. Schwab could have, the day before foreclosure sale, paid off his mortgage. But why wouldn't he do that? Well, he wouldn't do that because we would still be the owner of the unit. And the other reason he wouldn't do that is because the IRS will still have its lien on him. So he figures, well, kill 3 birds with 1 stone. 1, I own the property. 2, I get rid of Wycliffe. 3, I get rid of the IRS lien. Well, I pulled some case law some days ago and filed a brief which says you can't step into the former owner that defaults to multiple creditors can't pit the creditors against each other in a foreclosure proceeding.
Okay.
That's what I'm trying to say, because it doesn't make sense that somebody can come in and just default to everybody and then cut out the liens they don't like, and they come back and swoop back in and take the property over.
Okay.
So the IRS retains a position, and the IRS hasn't commented on that and said I'm wrong.
Okay. So SunTrust is gone because they got the $117,000.
SunTrust 2 is gone. Yes.
Okay. All right. And is Wycliffe essentially the other lady?
Yes.
Okay. Okay, well, that's why I know you so well, Mr. Henry. And I should also note that the senior judge using my courtroom today is Judge Baxter. So if I need to go get him, y'all holler.
All 1 week.
All right, who wants to go next?
Oh,
Okay, go ahead, Mr. Powell.
well, Your Honor, I guess I did misconstrue the briefs, the two briefs that were filed leading up to the hearing today by Wycliffe, because it did appear they were asserting their statutory / condominium documents lien for unpaid assessments through the date they foreclosed. So since they've disavowed that, all of that argument by the United States, the court can ignore. The issue pressing then is that they're claiming that they have the right essentially to resurrect their lien they foreclosed on because they got foreclosed on themselves for not paying a senior lien. Wycliffe foreclosed on a judgment lien and became the owner of the property subject to 3 liens. When a senior lien holder that primes the IRS foreclosed on the property, the IRS did get wiped out as to that property. Now, fortuitously, the recorded federal tax lien not only attaches to the property, but to that we're discussing here, but also to all property of the taxpayer in the county where the lien was filed. And true, if Mr. Schwab were to regain legal title to the property by operation of law, the IRS's lien would reattach as of that date, subject to the expiration dates. But the fact is, at this point in time, there was a foreclosure of property owned by Wycliffe subject to the IRS lien, and everything was wiped out, whether it gets to reattach through the fact there's a lien against the purchaser or the purchaser's nominee, which in this case, there's been nothing establishing that the separate corporate entity cannot own property separate and apart from its principals. At this point, there's nothing in the record showing the principals. There's nothing similar to like piercing the corporate veil to impute the corporation's property directly to Mr. Schwab. So that at this point, the IRS's lien really has not reattached to this property. It just attaches to all of the property that Mr. Schwab has or may have. So under the theory advanced by Wycliffe, they do not prime or get to take the money as the foreclosed upon owner, because there were intervening liens between the foreclosing lender and the property owner. And those liens by law have to be satisfied out of the proceeds.
Okay, let me ask a question that's probably right in front of me, and I can't see it. When SunTrust foreclosed, and it might have been, I mean, I don't mean in rem in a technical sense here, but when SunTrust foreclosed, the owner was Wycliffe.
That's right, Your Honor.
Okay. And that was a non-judicial foreclosure.
Non-judicial.
So nobody said, there's not an order anywhere that says the owner, Wycliffe, the title is being taken from Wycliffe. It's just a foreclosure on the property itself. Maybe that's not a good question.
Well, I think Mr. Henderson would need to speak. Well, yeah, not Mr. Gleason would have to speak to the foreclosure itself.
Okay. Okay. So you get the money.
The IRS is the only lien holder remaining after the foreclosure that has made a claim. The other claimants are Mr. Schwab, based on his former ownership before Wycliffe foreclosed. And now we know Wycliffe is claiming a right because they essentially paid $64,000 to acquire the property. And they should be able to now collect their $64,000, even though they were foreclosed on. by a senior lien that they did not pay off.
Okay.
To
Okay,
the extent the court would find equity, then we'd have the, unclean hands question. And, that actually goes all the way back to Wycliffe's judicial action for damages to enforce its condo lien and for foreclosure, because the United States was not given notice under 28 U.S.C. 2410 of that action, or under IRC 7425. We were not a party to the action, and
okay.
it's like they did that in secret and without telling all of the lien holders that they were seeking judicial foreclosure. That places some question on the court's jurisdiction in that case.
Okay, now, how much is the IRS lien?
Your Honor, I believe that's our Exhibit D to the brief filed yesterday, and
Okay.
got it here. Calculated as of today, $8,357.70. And we've got a 30-day calculation up to 8/19/2021 would be increased to $8,377.77. As you see, the per diem is not that large now because there has been some credit to the account.
So, Mr. Powell, let me ask you a totally hypothetical question.
Okay.
What if you had just said to me, the IRS lien is $18,357. Do you get all the 14 and then the balance remains attached?
Your Honor, the IRS the government would get the balance in that case under your hypothetical, and the lien would not be wiped out, but it would not be against this property. Currently, we have a lien against property of the taxpayer, Mr. Schwab.
Other property.
Any property, if he later transfers this to his own name, if the corporation deeds quit claim deed or warranty deed, however, to Mr. Schwab, and it comes into his ownership, at that point, the IRS lien would attach as of the date that he records that grant. Technically, as of the date that it was the document's dated, of course, nobody will have notice of it until it would be recorded. But by operation of law, the IRS can seize any assets, cars, boats, airplanes, homes.
So you have that, okay. So you have that lien right now. I mean,
We have a lien subject to statutes of limitations, which are not far in the future now. They were extended by the fact of the bankruptcy, but even with that extension, it's not an unlimited time period that we can go to collect.
okay. And I'm assuming everybody is acknowledging that this is a legal question to be determined, because none of you seem to have clients to put under oath. Is that fair?
Yes. Well, Your Honor, we only submitted declaration testimony, affidavit testimony.
Okay. Okay, excellent. Okay, Mr. Henderson, who gets the money?
All right. Yeah, I want to try to simplify a few things, clarify others. First, there are three claimants here. The IRS, who I understand is the only lien holder. Then there is Wycliffe, who is claiming the funds as the record owner of the property on the date of SunTrust sale. And then Mr. Schwab, who is claiming the funds as the individual who should have been the record owner of the property on the date of the sale, because Wycliffe's previous foreclosure of its association lien was wrongful. That issue is currently being litigated in the Superior Court of Cobb County in case number 19101-931. And what Mr. Schwab contends should happen here is that the IRS should be paid in full. Its lien should be paid in full from these funds, and the remainder should be sent over to the court registry in Cobb County to wait out the adjudication of that case. It's been fully briefed, I think, over a year now. COVID made things interesting, but it's ripe for decision over there. And the issue is, what impacted Mr. Schwab's bankruptcy have on this whole mess? So in going through the facts, Mr. Winterick said, in 2014, the association got a judgment from this court allowing, I think, awarding it $23,000 and the right to foreclose. Then he said in 2018, the association foreclosed. Well, a lot happened in between. In 2015, Mr. Schwab filed a Chapter 11 bankruptcy case. He submitted a plan. This was in the Northern District of Georgia. And in February 2017, that plan was confirmed. The effect of confirmation is very, very, very important. In First National Bank of Oneida versus Brandt, which is an 11th Circuit case, that's 887 F 3rd 1255. The court said, a confirmed plan of reorganization creates a contractual relationship between the debtor and the creditor, where the creditor's pre-confirmation claim is subsumed in and replaced by the new contract created by the confirmed plan. That's basically just a different statement of what 11 USC 1141 already says, which is that the plan binds the debtor and all creditors. So on confirmation, the Wycliffe Association's judgment was extinguished and it was replaced by this plan contract. The plan didn't give them the right to foreclose. So their rights at that point, if Mr. Schwab failed to make a payment, were just to sue for breach of the contract, not to go back to its pre-bankruptcy judgment and foreclose. That's why we say the foreclosure is wrongful. Their argument, they sort of conflate Mr. Schwab and architecture plus engineering and construction.
Can I ask a question?
Yes, you may.
Was Wycliffe listed as a creditor?
Yes, in the bankruptcy, yes, it was. Yeah, its claim was fully treated. There was some back and forth. I think Mr. Winterick represented the association in the bankruptcy. I did not act as debtor's counsel in that one. Would have loved to, but we did not.
Has the plan been fully executed and discharged?
No, it has not. This back and forth between the association, Ms. Kirsch, and Mr. Schwab sort of derailed everything. In candor to the court, so Mr. Schwab misunderstood what was required of him under the plan. He missed some payments. I believe Mr. Winterick filed what we call a motion for a comfort order, confirming that he could go into state court and seek relief. The bankruptcy court said, look, the plan stands, but sure, you can go adjudicate this in state court. On the eve of that hearing, Mr. Schwab paid all of the payments that had come due under the plan to that point. The association accepted them, which we contend thereby cured any default. He then continued to pay over the next few months, but the association, accepted the payments, but went ahead and foreclosed anyway. That's why we claim it was wrongful and unlawful.
So that's being litigated in Cobb Superior, not in the bankruptcy court?
That's right.
Okay.
We actually took this to the bankruptcy judge and she said, thanks, but no thanks. I'm going to let the state court judges handle this one. I'm going to abstain. And it was a bit frustrating because that's an issue that the bankruptcy judge sees every day. State court judges less so. And it's just a complete convoluted mess. Between Mr. Winterick and myself, we probably have, 200 pages of briefing in Cobb. So hopefully we'll get an answer there at some point. But the second issue here is the association refers to Mr. Schwab and architecture plus engineering and construction interchangeably. I understand this to be an alter ego argument, but it just doesn't work here. In Clark v. Coffin, this was 239 Georgia Appeals 226. Court of Appeals said, sole ownership of a corporation by one person or another corporation is not a factor in an alter ego analysis, and neither is the fact that the sole owner uses and controls it to promote his ends. I'm not stating any new or radical theory of law here and saying that a corporate entity is separate and distinct from its owners. Just as Mr. Schwab is separate and distinct from architecture plus engineering and construction. This was established in the deposition Mr. Winterick took of Mr. Schwab in December of 2020. He filed the transcript in this case on June 14th. At pages 34 through 38, there's this back and forth that establishes architecture plus engineering paid the money at the non-judicial foreclosure sale that brought us here. Mr. Schwab did not gift that money to the business before the foreclosure sale. And on page 38, Mr. Schwab testifies under oath that all of the money came from fees that his architecture business had earned. So their alter ego argument fails. At the risk of confusing matters a bit more, what they're actually trying to do is reverse veil piercing, which is not a viable claim in Georgia. So in traditional veil piercing, the court disregards a corporate entity and opens the door to its owner's assets. In reverse veil piercing, it permits collection of a debt owed by an individual from the individual's wholly owned business. In Corrugated Replacements v. Johnson, 340 Georgia Appeals 364. This is a 2017 case. The court said simply, quote, reverse piercing is not a viable claim in Georgia, end quote. That's just the law here. So he can't conflate the two. The association cannot say that architecture plus engineering construction is Mr. Schwab. That's not the case. And as acknowledged in Wycliffe's brief, they say if a stranger had bought the subject property at the sale, the IRS liens would have been divested and the IRS could satisfy its claim from this fund. That's exactly what happened here. The business is not Mr. Schwab. The business is a separate entity, and the IRS gets first dibs on this money.
Mr. Henry, let me ask you a question. The importance of the veil piercing argument, the side you're arguing is that removes Wycliffe's argument that debtors have somehow conspired to, or lien holders, excuse me, creditors have somehow conspired to squeeze out, in this case, his client's interest.
I think so, and I think we were also lumped in. He also included Mr. Schwab in that allegation that this was all some elaborate scheme to, I think he said, kill three birds with one stone. But this was just an entity that showed up on the courthouse steps and bid. There's no suggestion that we somehow chilled the bidding or stopped anyone else from showing up and bidding on the property. It was just architecture plus engineering and construction was the high bidder. I haven't seen any evidence of fraud or abuse of the corporate form that would allow this. And as I said, they're trying to say an asset owned by a business should be treated as though it's owned by the business's owner. That's reverse piercing, pure and simple, and it's not allowed. Have I cleared any of that up or answered the court's question?
Let's just say that was an answer.
I'm not sure what the conspiracy was, to be honest. I don't know how any of these parties could have acted in concert to eliminate the association's ownership of the property. It just
is Wycliffe a party in Cobb?
It is.
Okay. Well, you can see the little wheels turning about how do I get rid of this whole thing. But
yeah, well, that's
because Fulton's enjoyed it for so long.
Let me just try to simplify this very quickly.
Okay.
So I think everyone agrees if architecture plus engineering and construction, the foreclosure sale purchaser, is not synonymous with Mr. Schwab, then the IRS wins and gets paid first. That leaves the association and Mr. Schwab competing over the remainder. We contend that rather than having this court decide that issue, kick the balance over to Cobb County, let it sit in the registry until that court decides who wins.
Well, is there another solution as suggested by Mr. Winterick, which is give it to the owner upon whom the foreclosure fell, as what somebody used the term consolation prize. Was that you, Mr. Powell?
I think that was Mr. Winterick.
It's a consolation prize for getting undercut the 64,000, but I guess somebody, whoever's most appropriate, some question I'm going to have is, and I'm getting way out over my skis here, but if Wycliffe was foreclosed upon as the owner of the property by a mortgage holder, did they retain? And I don't know if it's redemption, right of redemption, or and I think there has to be a barment letter, or, you know, obviously a little learning is a dangerous thing, but could Wycliffe have come back and regained its ownership interest? Now, I'll start with you, Mr. Henderson.
I don't think that's a question we need to answer, because my understanding of the association's right in this case is just as the record owner of the property on the date of the foreclosure sale. It had no other claim to the property or debt, because it couldn't have. After the association took ownership, it was just the association and Ms. Kirsch running this whole duplex. There were no other fines, fees, assessments that could have come due against Mr. Schwab because they didn't own it. So when SunTrust foreclosed, the association was just wiped out as the owner on that date. And again, Mr. Schwab's position is that it shouldn't have been because the foreclosure was wrongful. So I'm not sure why it matters what the association paid or credit bid at all. You know, that ship sailed. If this were just a normal residential property and, you know, Jane Doe paid $300,000 for her house and lost it at a tax sale, it really doesn't matter how much she paid to acquire the property. The only thing that matters in determination of the interpleader is that she was the owner.
Except there are some very specific, strictly construed statutory provisions in a non-judicial foreclosure. Okay.
That's
All
right.
Well, okay. All right. Anything else? I'm going to let anybody, wait. We're going to go back in turn. Mr. Winterick, you want to tell me what I'm missing here?
Nothing yet, Your Honor. I think the court mostly gets it. Just a few things. As to the
you should get the money because you should. Because fairness dictates. You've been doing this. This lady's been doing this a long time, and this just doesn't smell right.
Well,
so you kind of should get the money.
I didn't interrupt. I'm sorry. No, there's a deposition transcript that doesn't smell right. It's an evidence that, and there is proof that Mr. Schwab, he could have paid himself and walked up to the courthouse and bought the property in his own name, which had been his property off and on since 1978. Or he could keep the money in his company and then use that money under the name of the company to purchase under his company's name. He chose to do it the way he did it. He couldn't come up with a single reason when I examined him why he had to do it that way. He said, I just thought it was a good idea. But what he achieved is he got rid of the Irs Lien, arguably, which is why obviously he's making us argue about it. So there was some purpose of doing it rather than paying the mortgage off, which he contracted to do. Your Honor, the IRS is something else, or Mr. Powell is something else. And he said that I don't have a judicial determination that there's an alter ego, and I don't. I mean, I'm not going to sue Mr. Schwab again. We've had 5 lawsuits, 3 voluntary dismissals by him. I don't want to sue him for judicial determination of alter ego. Your Honor, since we're in court, the court can decide for lien purposes, lien retention purposes, and for excess proceeds purposes that he is sufficiently tied to that company and to the money and to the unit, such as there being no other owners and no other control but him, such that he shouldn't participate in the excess proceeds. Not because we're so awesome, just because it's all gamesmanship, Your Honor. That's just an incorrectness I have to fix. And that's very important. If it wasn't for that, I wouldn't have anything to stand on. But he gave me plenty, and I did know somebody was going to say, well, it's this company that bought it. It's a third party. It's a stranger, just like anybody else. The IRS is wiped out. No, the IRS is not wiped out when the taxpayer purchases the property, doesn't end around so that it would appear not to attach anymore. So the fact that we have to talk about it means he created a roadblock, and it is gamesmanship, Your Honor. Mr. Schwab had a couple things, or his lawyer did. I'm sorry. As far as whether the foreclosure was wrongful back in 2018 or the sale that we participated in, this court was the forum for that discussion in 2018, 2019, and then they voluntarily dismissed that because he wanted to be arguing that case in Cobb County. Now that he's got Cobb County, he wants to argue it again here. The court here doesn't, I don't think, maybe I'm missing something. Maybe the court has jurisdiction, but it seemed like somebody else is deciding that. That action's already got those issues somewhere else. We'd rather be here because it was just simpler, but we're in Cobb. But the court shouldn't hear that argument. And frankly, I think we've already litigated that through as much as we're going to do it in Fulton. He didn't file a brief, so I couldn't put it in writing. But Your Honor, hello, Mr. Did I say something?
Samantha, you need something?
Oh, no, I'm fine. Thank you.
Okay, keep going.
Right. Okay, so the judge, I'm sorry, Mr. Henderson was talking about Chapter 11 bankruptcies, and he said that we had a judgment against Mr. Schwab, which was extinguished. That is not true. Liens passed through bankruptcy unaffected. We had a judgment lien that passes through the bankruptcy unaffected. So I don't want to, without belaboring the wrongful foreclosure talk, all we have is a lawful judicial foreclosure. It happened in 2018. There's been no court order that says that was invalid. Nobody has asked for maybe Mr. Henderson has, but none of the plaintiffs didn't ask for the relief to pay the money into Cobb. I would just ask the court to decide the issue instead of kicking it over. And the court would probably rather decide it itself. Your Honor, for excess proceeds purposes, Mr. Schwab's behavior of putting it in his company's name was gamesmanship, as is for purposes of lien retention. And that's why we think we're entitled to the money first. Thank you.
Okay, so school me on good old-fashioned foreclosure priority law.
Sure.
Let's just say, again, solely hypothetically, that this property is owned by Jane Barwick. I got a good old-fashioned mortgage to SunTrust Mortgage. I also owe the IRS a lot of money. I don't pay my mortgage. My mortgage company comes in, forecloses, non-judicial foreclosure, and credit bids in the credit bid on the courthouse steps. What happens to the IRS lien if the mortgage holder forecloses on a credit bid?
Sure.
Or buys it on a credit bid?
Yeah, the word I think the court's looking for is a power of sale, because the power of sale lets the foreclosing lender bid and purchase if they're on sale.
Right.
Okay. So credit bid is judicial language. So because the court asks, normally your SunTrust mortgage would depends on the circumstances. The IRS lien would survive by default, but normally the SunTrust lawyer, let's say we'll call him Mr. Gleason. Mr. Gleason's going to send a letter to the IRS that gets their lien to divest the IRS, and then the foreclosure takes place and the IRS is wiped out unless they come back and redeem. So if Mr. Drew Gleason sent the letter that he was supposed to send, which I think he did in this case, he sent the letter that he was supposed to send. IRS is wiped out. A stranger comes to the courthouse steps, and the stranger buys it. The stranger buys free of the IRS.
Okay.
If Barbara comes back to the courthouse, and then she wants to buy her own property back from the foreclosure, the IRS lien attaches, because Judge Barwick can't get rid of that IRS lien just by coming and purchasing it on sale after she defaulted on that mortgage.
Okay, fact number 2. Jane Barwick owns this property. SunTrust under the power of sale. I understand and agree. Non-judicial foreclosure, credit bids, or puts in its credit bid, buys the property at foreclosure, but Jane Barwick owns another piece of property. does the IRS lien just shift over to my other property?
Mr. Powell said so. I don't know the answer firsthand, but Mr. Powell said so. I believe that. I don't argue with it.
Mr. Powell?
Well, Your Honor, first, if you look at the notice of lien for federal taxes, it attaches to all of the taxpayer's property, real and personal. The fact that it's recorded in the lien book ensures that it attaches to all of his property.
Okay.
If we have after acquired property at that point, it attaches as well. That's just like a judgment lien. The FIFA that the association had recorded on its judgment, that would have attached to all of his property, not just this particular unit as well. And they could have had the sheriff go out and execute against any property that could be found, just like the IRS, a car, a boat, a plane, anything he has that's of value could have been sold to satisfy that lien, because they had a judgment against him and recorded it against the property to attach to his property.
Well, then, Mr. Powell, here's a question. Why don't you go after Mr. Schwab's other stuff and let Wycliffe have this money?
We have the priority, Your Honor, and the fact is we have the right to enforce our lien that was on this property now that we've been wiped out from SunTrust's foreclosure sale. It's no moment that it doesn't matter that we have liens against Mr. Schwab, and if he acquired the property again, our lien would attach. That's not the facts in this case. The facts in this case are that no matter what property he had, the lien attaches to all of it. And if this property is liquidated, subject to our lien, then the liquidation proceeds to the excess of the senior lien holder, we're next in line for. So the United States would get up to the amount of its lien. And as far as you'd asked about equity of redemption earlier, Georgia has two different types. If it's a local government foreclosing on property tax lien, there is an equity of redemption, and it runs for at least a year, and then notice of barment can be given, and with a date certain by which funds have to be tendered, and the statutes dictate what has to be paid. And anyone that has an interest in the property can redeem. And if they don't, then the purchaser at that point gets good title to the property through a quiet title action, most often is what we see. As far as a normal foreclosure, as both of the foreclosures here were, whether it's judicial or non-judicial, there is no equity of redemption.
Okay, all right.
Okay.
I got my
Except now the
metaphor.
federal government reserved to itself a 120-day equity of redemption for in case of tax liens, where it could go in and redeem under the requirements of federal law, not state law. But I've never seen that exercised by the federal government in 20-something years. So, but anyway, there's that statutory right under 28 U.S.C. 2410. But under Georgia law, there is no equity of redemption on a foreclosure. So once the property is sold, the property owner has no recourse other than possibly a suit for challenging the legality of the foreclosure.
Okay.
And
I'm sorry.
I did want to point out that there was discussion of the IRS gets paid for its statutory, its recorded lien, and the remainder be remitted to Cobb Superior Court until that case is disposed of, which would be dispositive of who really, between the two parties there, should get the right to what's left of the excess proceeds. The United States also has statutory liens for 2013 and 2014 taxes against Mr. Schwab at approximately $2,500 to $2,600, with small accruals going along. Now, if he were to have a right to any of the proceeds beyond what is owed on the recorded liens, the IRS would have the right to attach and receive its statutory liens out of what amount he receives. So the United States in that case would have an interest in the Cobb County case amount until it's determined. And if the association winds up getting the money, the IRS gets nothing. If Mr. Schwab gets the remainder, then the United States would be able to collect those statutory liens.
Okay. But the IRS acknowledges, and that may be too strong a word, the IRS acknowledges that the amount owed, which is the subject of the IRS lien, is still owed by virtue of that lien being having the general language in it that it's against Mr. Schwab.
Yes, Your Honor, just as the condo association's lien would have still been against all of his property had they not foreclosed on one piece of property and satisfied their lien.
Okay. Anybody else want to say anything?
Yeah, just to chime in, the way I think we've been talking about the IRS being divested of its claim, I think really its claim against the fund exists to the same extent and priority as it existed against the property before. It just substitutes the fund for the property at foreclosure. And Your Honor, a few minutes ago asked about, is there any guidance on how this should be paid out? Surprisingly hard to find. There's not a statute on point. It appears to be the closest you can get is a 44-14-190, which suggests the surplus is paid according to the rules of priority. That was at least the understanding I got from reading Tower Financial Services v. Smith. It's 204 Georgia Appeals 910. Just wanted to cite that. It may be helpful for the court to help us sort through all this.
Okay, Mr. Winterick, last word.
I don't have anything else, Your Honor. Thank you. I thank you for listening to probably the most dry type of dispute.
No, gosh, are you guys kidding? This could be a liquor store holdup. I got plenty of those. This is fascinating, and I'm sorry that I interposed a little bit of. I mean, I was fascinated, so I'm sorry I asked so many questions. But do I have my equity hat on, Mr. Winterick, or do I have my statutory hat on?
So Your Honor, I think the only thing I could find that governed what the court does was case law, which I put in the briefs, and I'm sorry I didn't keep the names because it just takes up time.
I've got it
Case law.
in front of me.
Case law, yes.
Okay. Y'all are great. Thank you so much. Now, right now, I'm going to take us off YouTube so that it doesn't